Greetings and welcome everyone. Thank you all for being here and joining us for session 4 of our Juvenile Policy and Code Development Virtual Learning Series, hosted by the OJJDP Tribal Youth Resource Center. Today's session is entitled Integrity of Tribal Juvenile Court Process as a Foundation, Implications of Rights and Evidence in Juvenile Court Process. This is Laura Smith from the Tribal Law and Policy Institute. I serve as a program assistant with the Tribal Youth Resource Center, and I'll be walking us through a few tech-related notes for today's online learning event. Please note that your control panel will appear on the right side of your screen, and that all attendees can resize their screens to the desired size. All attendees will be muted during today's presentation to help limit background noise. Once you call into the meeting line, enter your PIN number to integrate the audio. If you'd like to minimize the control panel, you can do that by clicking the orange arrow at the top left of your panel. At any point throughout today's session, you can use the questions box on your panel to submit questions and responses. If you'd like to download the PowerPoint that we'll be going through today, you can find that under the handouts pod in your control panel and download it at any point. Also, following the session, we'll be sending out an email to all attendees that contains a link to the evaluation for today's online learning event, as well as the session slides. And we'd be really grateful if you could participate in that evaluation. And we'll also include the link here in the chat at the end of our session. And with that, I will turn the time over to co-director of the Tribal Youth Resource Center and lead for Healing to Wellness Court Programming, Anna Clough.
Thank you, Laura. And so happy to be here today. Hope all of you are doing well, continuing to stay healthy in light of the many impacts that we faced over the last year, and want to welcome all of you back to session 4. It's been a little bit since our last session. We took a little bit of a break toward the end of the year, and we are resuming. So welcoming all of you back with us today. We are joining on behalf of the Tribal Youth Resource Center. We are a training and technical assistance provider for the Office of Juvenile Justice and Delinquency Prevention. We are currently located at the Tribal Law and Policy Institute and very happy to partner with the National Native Children's Trauma Center. A great opportunity to be working alongside many tribal communities who are working on prevention, intervention, and various diversion programs to support tribal youth. And we do believe that our children are sacred. So again, thank you to all of the work that you are doing in your community. We are happy to be here today and engaging in training that can support your community in the work that you do. Next slide. And we want to welcome back the Honorable Pat Sekaquaptewa. She is joining us from Alaska and will be working through our next section of materials. So welcome, Pat, and she'll be on here shortly. We can go to the next slide. And that's a picture of me. I've already introduced myself. Work for the Tribal Youth Resource Center alongside a wonderful team located across the country. I'm very happy to be here today to help facilitate our questions and our polls and assist Pat as she shares this section of material. Next slide. At the Tribal Youth Resource Center, our primary services that we provide to OJJDP grantees are under CTAS Purpose Area 8 and Purpose Area 9, and those are Tribal Juvenile Healing to Wellness Courts and Tribal Youth Programs. We also serve any other federally recognized tribe with training and technical assistance, and so for any communities who are not currently funded, the resources and assistance available at the TYRC can be accessed at any time through a training and technical assistance request, and we will put that link in the chat. Next slide. I believe this is Pat.
Hi folks, this is Pat Sekaquaptewa here, and today we're going to go live because it has been below -20 degrees in Fairbanks and I'm unable to get video out to you pre-recorded. So cross fingers that the weather will keep us going here or will not halt us. So the overview for this session states that we're going to talk about rights protections from the Model Indian Juvenile Code of 2016, and also the purposes and processes of the hearings under that code. However, we covered a lot of that last session, so we will have a bit of review of some of that material at the end of today's session. But this session, I primarily want to look at the key positions in a juvenile court under the model code and some of the nuts and bolts of that process. Next slide, please. So specifically, the learning objectives are to look at the key positions, especially that of the juvenile case coordinator, and a new kind of function that this person will be responsible for under the model code, which is the maintenance of a directory of services. The third thing that we'll do, or you'll learn in this session, is that there are a number of doors to diversion, and we're going to look specifically at those code provisions and the diversion options that go with those doors out of the juvenile process into other programs and services, including the Healing to Wellness courts. And then finally, we'll review again some of the juvenile court processes that implicate rights and standards of proof, just so that we remember what's happening to those other youth who are not diverted. Next slide, please. Okay, so the key figures or the key positions for a tribal juvenile court set out in the model code are under section 1.02. This is the definition section, and it's H, I, J, and K subsections. So this time I thought I would share some of the commentary that the code drafters put in the code for these sections. And they start out by saying, specifically with respect to this juvenile advocate position, that they made a deliberate effort to distinguish between juvenile and criminal proceedings in the model code. So the role of the juvenile advocate, who is an attorney who is appointed to represent children in delinquency, child in need of aid, and truancy proceedings, should not be conflated with that of a public defender. That is an attorney who's appointed to represent adults in criminal proceedings. And I think the drafters were making an effort to cause us all to think about juvenile proceedings as civil proceedings. So we don't, sort of lapse into thinking about youth as baby criminals or criminals in the making, because that will affect how we start to think about them and talk about them. Now, I know in the last session, I was defaulting to some of the criminal terminology like sentencing criminal charges, for example. I was using some of that language, and it's tricky not to do it when you start talking about rights protections, because we're elevating the rights protections in our juvenile civil proceedings to the level they would be in a criminal proceeding. So it's a tricky maneuver, but let's just keep in the back of our minds that under the model code, our juvenile court is a civil process dealing with youth, not criminals in the making. Okay, so let me first just say these are the 4 key positions. The guardian ad litem, or the GAL, is usually a volunteer who is appointed by the trial court judge to look out for the best interest of the child. However, they are not the legal representative. They're not the attorney substitute for the youth. That is the juvenile advocate in this code. Another key position is the juvenile case coordinator. And I'll hold off there for a second. And then finally, the juvenile presenting officer, who is what we would have thought of as the prosecutor in a criminal proceeding. So the lawyers here are the juvenile advocate, the JA, and the juvenile presenting officer, the JPO. Okay, let me come back to the juvenile case coordinator. So according to the commentary, this person is in some respects similar to that of a juvenile probation officer. The JPO title suggests an analogy between juvenile and criminal proceedings, which is not favored by the model code. So they're not calling this person a probation officer. The responsibilities of the juvenile case coordinator go far beyond monitoring compliance with court orders and court-ordered conditions. So think of this juvenile case coordinator as kind of like a civil probation officer with additional responsibilities. Okay, next slide, please. All right, so I think I've already talked about the GAL, but we'll just go over it again here. They're appointed by the judge, the juvenile court judge. They represent the best interests of the child. And you can have a GAL in all the proceedings that are under the model code, I believe. I'm pretty sure a judge could modify that by order or directive if they wanted to. I'll have to check on that. Actually, that question just popped into my mind. All right, let's do the next slide. Okay, so this is the juvenile advocate position. So this is who would have been a public defender if it were a criminal process. So this is an attorney where private counsel has not been retained. So the young person and their family do not hire their own lawyer, probably because they cannot afford it. So this is the tribe paid for lawyer for the young person. This person is appointed by the juvenile court to represent the child in proceedings under the code. And there was a later commentary that the code disfavors lay advocates representing juveniles unless they are trained up. Let's say you had a tribal bar exam and they could pass it just like an attorney could. But in general, the practice of lay advocates to fill this position are disfavored under the code unless they have the same level of training. Okay, next slide, please. Okay, so now we're looking specifically at the juvenile case coordinator position. And again, this is kind of a probation officer plus in the civil juvenile court, and they're responsible for a number of things. The first one is that they're an unbiased liaison between the child, his or her parents, guardian, or custodian, any agencies, any service providers, the school officials, victims, the community, and the presenting officer and the juvenile court itself, the judge. So this person has a lot of liaison responsibilities here. The juvenile court coordinator is also responsible for coordinating services for children and for providing recommendations to the juvenile presenting officer. That's the person who would be the prosecutor in a criminal process. The juvenile case coordinator makes recommendations about whether or not proceedings should be initiated or things should be filed in the juvenile court. So is that case going to move on down the line toward a trial in the juvenile court, or is the recommendation that that case goes through some kind of informal agreement and gets diverted out of the juvenile court process? And so then the JCC also makes recommendations about diversion or other alternatives. And then number 4, the JCC makes recommendations regarding the disposition. That means the case didn't get diverted out of the process. It goes all the way through its trial, and then it goes to disposition before a tribal court judge. And now the JCC is recommending what the disposition or the sentencing, if it were a criminal process, could or should be in that particular case. Next slide, please. Okay, so it keeps going. There's a list here, quite a list. Other responsibilities of the juvenile case coordinator. They also are responsible for monitoring and facilitating compliance by both the child and his or her parent, guardian, or custodian. And these are conditions that are either in a diversion agreement or they're conditions of release that are in an order, a court order, or in a disposition order. So the juvenile case coordinator has to keep track of whether or not the young person and their parents, for example, are meeting the requirements in these agreements and orders, and if they're not. Okay, number 6, the juvenile case coordinator is responsible for conducting mental health and other screening of children to identify services which may be necessary or appropriate to meet their needs. Now, I don't think the code means that they do mental health screenings. It just means they do the pre-screening to get them to the mental health screenings and other screenings here. Okay, number 7, performing related functions. There may be other functions that you have your JCC undertake. Okay, next slide, please. Okay, so the next position then is the juvenile presenting officer. And this is the person who would be the attorney or the prosecutor in a criminal case, and they represent the tribe's interest in, I would say under this code, the tribe's interest in a therapeutic response to the youth, but also in protecting the public, the community. And so they are adverse. They can be adverse to the interests of the child if they are sort of overly representing the community versus the therapeutic interests of the child. But this is not the attorney for the youth. This is the person who would have been a prosecutor in the criminal process. So they're known as the JPO, the juvenile presenting officer. Okay, next slide, please.
And Pat, I think we had a question that was relevant to the juvenile case coordinator. It was a question about the JCC. Does the JCC remove barriers for the juvenile?
Yes, if we mean, well, I suppose we could mean barriers in multiple ways. I mean, it could be things to do with service provision and their family environment. But it could also be getting stuck in the juvenile court process and not getting diverted out to have programming and services. You know, as we move through this section, if whoever asked that question, if we're not answering it, ask it with a little more detail. But this might answer some of your questions. So section 1.06110A is the directory of services. And the juvenile case coordinator under the code is interestingly, and it's a good thing, is required to compile and maintain a directory of services and resources for children and their families. And it's all kinds of things. Look, there's 18 things here, from crisis intervention, and look at all the things here: counseling, mediation, victim offender reconciliation, diversion programs, assistance and education for victims or perpetrators of domestic violence, parent training, education and support, homemaker or parent aid services, housekeeping services, childcare services, short-term respite care. That's like having a youth home or a place where the people have training and services for young people, where young people can go spend the night or a couple of days. And I know we lack that respite care function. on a lot of our reservations and in our communities, but that is a possibility here under the code. Also runaway shelters, emergency shelters, residential placement, chemical dependency evaluation, treatment and intervention, mental health screening, assessment, treatment and services. Same thing, education assessment, evaluations and advocacy, special education, tutoring, remedial academic services, vocational and job training and employment services, and programs for building resiliency skills. Now, I know there may be many of you out there thinking, well, this is a nice menu, but how do you pay for all of this? And we don't have all of this. At this point, the code is just setting out a job requirement for this juvenile case coordinator to do the work of going out and identifying what is actually in your system or available to your system and cataloging it so that you know what you do have, and then you can know what you need to go get or prioritize getting. And it just makes it their job to stay up to date with this so they don't all kind of get old and are no longer applicable. Okay, Anna, did we have another question, a follow-up question on this?
Not yet.
Okay. Next slide, please. Okay, so in order to keep that directory up to date, the juvenile case coordinator is required to consult periodically with schools, agencies, law enforcement, the JPO, the juvenile advocate, and the juvenile court. So the code is basically hardwiring a job position requirement in to that person's job, but doing it through the code. And then you need to go update your job positions to make sure that the JCC has all of these duties in their job position. Okay, next slide, please. Oh, before we do the poll questions, let me just tell you the commentary on the JCC. So the commentators or the drafters of the code said, the range and scope of responsibilities for the JCC is greater than for a probation officer. So special consideration should be given to the qualifications and training required for people in this position. Also, the supervisors and also tribal council should notice that they should adopt an appropriate caseload limit for the JCC. And currently, national standards are recommending a 25 to 1 person ratio for traditional probation services. And now remember, the JCC is responsible for more work than what a probation officer would be. So even the 25 youth to 1 juvenile case coordinator could be too much in a tribal community, depending on how much responsibility you require of the JCC. Okay, good, I got that one in. Okay, we can do the polling questions now.
Thank you, Pat.
Okay, so what are 3 of the 4 key positions in a tribal juvenile court? Select one of the following: advocate, case coordinator, and presenting officer, or public defender, probation officer, and prosecutor, or lay advocate, judge, and probation officer.
And while we wait for those answers to come in, Pat, I'll say the first question that came up has been answered, and then after we close out these polls, we have another question.
Okay. We need our Jeopardy music right now.
I know.
Okay, so great. The right answer is advocate, case coordinator, and presenting officer. And remember, the reason we don't use public defender, probation officer, and prosecutor is because we don't want people to think of the juvenile court as a criminal court with baby criminals in the making. So the code drafters really want us to avoid those middle answers. And then it is true that there is a judge in the juvenile court, but the code is really listing those other 3 positions as the key positions. Okay, and did we have another question?
We did, and we can either ask it now or we can continue on with the polls. Let me know what you prefer.
Let's go ahead and see if we can answer it.
Okay, we had a question that was JDAI Annie E. Casey has funds for juvenile justice reform addressing least restrictive measures. This might be more of a comment and a question. I was a community coach to address needs for youth of color with trauma-informed care. Have you partnered with state agencies to address least restrictive measures, alternatives to incarceration? So I think that might have been a broader question for both of us and then TYRC wide.
Okay. Did you want to have a first stab at it?
Sure. So I know that recently we held a listening session with OJJDP in regards to updates to the Juvenile Justice Reform Act, and one of the issues that has come up consistently is the use of least restrictive means. I believe that would be a recommendation made on behalf of the TYRC and then OJJDP following most recent guidelines. And so I think as a follow-up, we could just, if there's specific questions about that and implementation, we could do a TTA request to assist with follow-up for that.
Okay, so from the code perspective, the model code perspective, you most certainly could access money and or programs and services in collaboration with state funded or state organized programs and services that are not secure detention. But the code does favor, or should I say disfavor, the mixing of populations of youth who are not adjudicated with those who have been adjudicated but then put in other programs. And I think the thinking behind that is that you have 2 different kinds of youth. You have those who've never really touched the juvenile justice system, and you may have youth that have a lot more experience in the system who maybe have habits and tendencies that you don't want your untouched population to come into contact with. So you just have to think about whether that dividing line from the code perspective is, have the youth been adjudicated or not? And are you pouring them both into the same programs or the same pool? And it's disfavored to do that if they're youth who've not been adjudicated. Okay, Anna, are we getting more questions?
For right now, no. And then I was just going to say, as a follow-up, I know that when we work with communities who are developing those partnerships with MOU and other referral processes, I think that those are some things that could be stipulated in those agreements. So I know that there's ways to address that issue, and I think they're good conversations to have when you are working on those partnerships for referrals into the court, and then vice versa when you have youth that are already engaged in a state system and they're not able to be referred for whatever reason.
Okay, great. Sounds like a lot of people are thinking about this. Let's do the next poll. Part 1, and this is part 1, which is which of the following are juvenile case coordinator responsibilities under the model code? Select one or more of the following: to be an unbiased liaison, to coordinate services, to provide recommendations, to monitor and facilitate compliance, and to conduct screening. And now you can imagine the Jeopardy music. Okay. So lots of people picked lots of things, it looks like. We've got over 60% for most. The answer is all of them. All of these are responsibilities of the juvenile case coordinator. So, so just remember, I mean, think about that job. Would you want that job if you had a too high of coordinator to youth ratio, right? If you were serving 100 youth, this is a lot to do, from liaising, I guess, coordinating services, recommendations, monitoring compliance, and conducting screening. It's all of these things. Okay, any questions so far?
No other questions right now.
Okay. Next poll. What legal instruments are used to divert cases to programs under the Model Code? So legal instruments. Select one or more of the following. None. Voluntary walk-ins are the way that people get into programs, the only way. 2, diversion agreements. They're like contracts. 3, court orders that defer adjudication, which is the trial. 4, court orders deferring disposition, which is like the sentencing. Pick one or more.
All right, and the responses are still coming in, so we'll leave it open for another 10 seconds or so.
Okay. And I'm realizing this poll might have jumped the slide where I tell you the answer. So it's okay if you get this one wrong. It's okay if you get them all wrong, but there's no grading. Okay, so the legal instruments. Most people said diversion agreements and court orders deferring adjudication. The answer actually is all of the bottom 3: diversion agreements, court orders deferring adjudication, and court orders deferring disposition. Now, I give you brownie points if you got the middle 2, because that's usually where you want to do it. The code says you can do it in of the bottom 3, right? Agreements, deferring adjudication, deferring disposition. You can do that, but most people will want to do the middle 2, because that's when you can still kind of hang things over the head of the young person and say, hey, if you don't want to go to a trial and go before the judge and get found to be a delinquent, go to our diversion program. If you graduate from that, it's like you never went to court, and we can get it all dismissed. If you wait until the very end here, when there's sort of a sentence, you know, they've already been found to be juvenile, have committed a delinquent act, then it might be harder to get them to agree to the diversion program. But you can do it. It's legally possible under the code. Okay, any other questions?
I'm making sure. No other questions right now.
Okay, so in order to sort of talk us through the next section, I need to have an evidence pattern or a fact pattern. So I just picked something from my childhood and made something up. So this is the Hopi Mission School. This is where I went to my elementary school. And they had a playground with this fantastic slide. It was a giant slide. And of course, I was just a little kid, so it looked huge to me. And I went and found a picture of what I thought I remembered it looking like. So here's my giant super high slide that I remember from childhood. And here's my fact pattern. So the Hopi Mission School purchased and installed a new super high slide for the playground. And this is according to an invoice and a work order. We know this. We can also go see the super high slide and take pictures of it. 3 boys who attended the school, Adam, Barney, and Charlie, tell their classmate X that it would be funny to lure another boy they don't like, Harold, to the top of the slide and to push him off. Classmate X sees two boys push Harold off the top of the slide. At recess on Monday, September 15, 2020, the emergency medical services is called to respond to a boy, Harold, who is found to have broken his arm and has other bruises. Classmate X tells the principal what was said by the other boys, and he recalls smelling alcohol on the breath of Adam, Barney, and Charlie. Now, if you're a juvenile healing to wellness court person, you realize that our juvenile fact pattern has to have an element of substance use in it. Otherwise, these folks might not be candidates to be diverted into a healing to wellness program. Okay, so under the model code, a delinquent act is defined in the upper left-hand corner in the gray area on the slide. A delinquent act is an act committed by a child that would be a criminal violation of the tribal code if committed by an adult. So we don't have a clear answer here. We have to get diverted off to the tribal code here. So I went and got my Hopi criminal code, and I found this crime of assault, and I parsed out the elements here for you on the slide. So an assault is where a person commits assault by attempting to cause or recklessly causing physical injury to another person. So luring a kid to the top of a slide and pushing them off is at least recklessly causing physical injury, if they're injured, to another person. So the model code would absorb this definition of assault from the Hopi criminal code, and that would be used in the petition in juvenile court to say that one or more of these boys, Adam, Barney, and Charlie, were committing a delinquent act. Okay, so hold this in your mind, and let's go back to the model code slides. Next slide, please. Okay, so if we run this hypothetical through our diagram in the model code, someone, I mean, it could even be EMS services here, or it could be Harold's parents, allege that those three boys, Adam, Barney, and Charlie, committed a delinquent act when they did what they did here. And at that point, that allegation in some way makes itself to the juvenile case coordinator. And then that job position under the code investigates this allegation and also contacts the parents or the guardians or the custodian of these boys to see if they want to do some kind of informal adjustment or divert this case to programs and services. See if we can deal with whatever caused them to do this. Were they drinking? Do they have other conduct problems? Are the parents not supervising them well? Is it all of the above? Can we get them services and programs to intervene before we ever file a petition in the juvenile court? If yes, an adjustment is done, a diversion agreement is done, and the juvenile case coordinator works with them through that process. But let's say either they don't complete the agreement conditions, or they won't meet with the juvenile case coordinator, the youth and their parents. So at that point, the juvenile case coordinator recommends to the juvenile, now I'm forgetting the name of the lawyer, the JPO, juvenile, I don't know why I just slipped my mind, the lawyer who would be the prosecutor for the tribe, recommends to them to file a petition in juvenile court. This is a delinquency petition. So at that point, the case is formally filed in tribal juvenile court, an initial hearing is scheduled, and that's where a probable cause determination is made by the judge to determine whether there's enough evidence of the allegation to go forward in the petition. And At that point, a motion can be made either at that hearing or after that hearing. A motion can be made by the young person and their attorney to defer adjudication. Let's not go to trial. Let's try diverting this case to programs and services again before we actually do a trial. And again, if that works, then they can come back to the juvenile court and have the whole thing dismissed. But if it doesn't work, the youth and their parents and guardians and custodians don't meet the conditions, now the trial gets scheduled, the adjudication gets scheduled, and the whole shebang happens. Trial, rules of evidence, competing lawyers, just like on television. At that point, someone has to prove that these young people committed a delinquent act with evidence. And if they're found to have committed the delinquent act, then a disposition hearing is set to do the sentencing if it were a criminal case. But notice there's still one more opportunity here, that the youth and his lawyer can file a motion for deferred disposition. Let's not sentence this young person yet. Let's try to do diversion to programs and services first. And if that works, we can have the whole thing, well, it's not dismissed because they're already adjudicated a delinquent, but the disposition could be modified to something more favorable. Okay, the fourth bubble is the actual disposition hearing and the order that comes out of it. And it is still possible that the judge could order programs and services instead of secure detention at this very last bubble. But as some of you may have observed, it's not the best time to divert a young person to programs and services, because at that point, they're like, oh, well, if that's all that's going to happen to me, then just give me the sentence. I don't want to do all that work in the program. So you can do it under the code if you're the judge at this point to send them to programs and services, but the better time to have done it would have been earlier, in the earlier bubbles. So those are the diversion doors under the model code. Okay, do we have any questions maybe at this point?
I'm going to check. We don't have any additional questions at this time.
Okay, and if you're wondering why I have to keep checking in, the type is so small on my computer, I can't see it. Go to the next slide, please. Okay, I have to get some of my notes for this one. All right, so by now you're starting to realize that there are these legal instruments that divert cases out of the juvenile court into programs and services, and I've showed you the doors. The legal instruments are the diversion agreement, early bubble, first bubble. An order deferring adjudication, that's the second bubble. An order deferring disposition, that's the third bubble. And the code talks very specifically about these three doorways or bubbles. So these agreements or orders may include, first, referral of the child and his or her parent, guardian, or custodian to social, community, or tribal services or resources. 2, refer the matter to an elders panel, a community accountability board, a tribal council, or other forum that will address the needs of the child and or the community. 3, participation in tribal peacemaking or other extrajudicial alternatives for resolving conflicts or disputes. Now, there was a lot of commentary on these, so let me kind of walk back a bit here. So overall, the commentary says that the list of options was drafted to provide tribes with considerable latitude in identifying and selecting appropriate services, interventions, and alternatives to adjudication. And I'm sure the latitude both has to do with culture and resources. What you have, given what you can afford, and cultural tailoring. Okay, let's see, there was commentary on number 2, the elders panel, etc. So the commentators said that in addition to tribal healing to wellness courts, mental health courts, and drug courts, Some jurisdictions have implemented youth courts or peer courts in which other juveniles can address cases that meet certain criteria, like it's a first-time offense or the offenders are very young. Those are the typical scenarios where you would have a youth court. Okay, there was also commentary on the third one here, which is peacemaking. And the commentators say that similar alternatives might include victim offender mediation or reconciliation programs. So you really can read, more things into the words here about what can be included under the model code. Even the commentators are coming back and identifying more possibilities under 1 through 3 here.
Now,
Okay.
Pat, I'll just share some commentary there about the youth and peer court option. I know we were talking earlier about the referral list of all these various programs and opportunities that are available, but when you think about resources and capacity, that, you know, some of these diversion programs do cost quite a bit of money, but the great thing about the youth and peer court option is that on a volunteer basis, if you have those youth come in, that's a wonderful opportunity to engage them in the system, and then also very low costs as associated with that diversion process.
Yes, and remember that that's a special kind of program for first-time offenders, low-level offenders, for example. And you should have those options. You should have the full menu if you can. But don't put all your youth in it, right? Because they don't all fit those criteria. Okay, next slide, please. All right. So there's more, 4, 5, and 6 here. So these agreements and court orders to diversion can also include 4, participation by the child in cultural, educational, or other programs or activities aimed at rehabilitation, community involvement, or competency development. And here you're really looking at meeting the needs of the child. 5, participation by the child or the child's parent, guardian, or custodian in an educational or counseling program designed to deter delinquent acts. So these are tailored. Or other conduct or conditions which would be harmful to the child or the community. But note here that the code is giving the judge power to order parents, guardians, or custodians to educational or counseling programs. 6, participation by the child's parent, guardian, or custodian in an educational or counseling program designed to contribute to their ability to care for and supervise the child, including but not limited to parenting classes. So there's more here, more kinds of things that the judge can order the parent, guardian, or custodian to do, specifically regarding parenting. Okay, next slide. Okay, so there's a 7, 8, and 9 here. So the agreement or order may include 7, a requirement that the child or the child's parent, guardian, or custodian undergo medical, psychological, or psychiatric examination or treatment. 8, the agreements or orders may include a requirement that the child pay restitution. That means some kind of compensation for the harm caused to the victim. 9, these may include performance by the child of community service, and this is an old standard court-ordered kind of requirement for a child because it's the easiest thing and doesn't require money or programs. So that's just a standard inclusion. Let's see, I think I'm just showing you an example of an elders panel on the right-hand side. One of these elders panels, and it might be this one, it was interesting to me because it was kind of a splice between a juvenile healing to wellness court and an elders panel. Like they required drug and alcohol testing, and there were other kinds of accountability requirements in it. Don't hold me to Tulalip. It might have been the one before. I'll have to look it up. But interesting splicing of different programs and services going on here. Okay, next slide. Okay, there's more, 10, 11, and 12. So your diversion agreement or your court order may include a requirement that a child maintain satisfactory school attendance or otherwise pursue a course of study designed to lead to achieving a high school diploma or the equivalent. It may also include, under 11, participation by the child in structured after-school, evening, or court-approved programs. This could be a tribal healing to wellness court that is appropriate for addressing the needs of the child and providing for the safety of the community, and other reasonable conditions aimed at holding the child accountable for his or her actions, providing for the safety and protection of the community, and promoting the development of competencies which will enable the child to become a responsible and productive member of the community. Okay, there is commentary on some of this. So number 12, the commentary from the drafters is that this section invokes the principles of balanced and restorative justice, and that this idea informs much of the code. What does that mean? To me, it means that in addition to designing a juvenile code that's prioritizing therapeutic possibilities for young people and not just punitive ones, that the code is also in its diversion and programs requiring some accountability for young people for the harms they've caused, and just to recognize what they've done. And that there has to be an accountability aspect. Now, it's not what I realized is they're not saying punish them, throw them in jail, detain them. That is not accountability. Accountability are other programmatic or activities that require that young person to see what they did and hold them accountable to themselves and before the community for what they've done. And it usually shows up in programming and services, not in detention. Okay, next slide, unless there's a question.
I just had a question regarding, if we step back just a little bit, regarding the restitution, and just in consideration of restitution or fines or fees that we associate with trying to make a situation right, but also that balance in looking at restoration between the youth and the community. So I know that comes up a lot when working with communities, and we're talking about, how do we address the need to make restitution, but also not inhibit families further with, heavy fines or costs associated with their case.
Yeah, money restitution it is arguable that punishes the parents. And it makes it hard for them to move forward in the therapeutic process if they don't have the money. So people should definitely red flag money restitution as maybe not achieving the goals that were meant to be achieved because of the barrier of money. Find other ways to make a victim whole or to pay back the community that would be meaningful and achievable by people who don't have a lot of money. And the code doesn't go into that depth of detail, so that would really fall back on the tribal community and the way you draft your model code, or maybe you just leave that up to the judge and the program implementers and/or, yeah. Okay, let's look at the last section here. Section 2.06150B. We've been looking at A, so now we're looking at B. And these are all the things that the agreement and the court orders cannot include. So the agreement and court orders shall not include detention in a secure juvenile detention facility, nor participation in alternative programs or services intended as alternatives to secure detention. Why? Because remember, we don't want to mix the population of youth who haven't been adjudicated in programs and services with other youth who've already been adjudicated. And we don't want to put youth who've not been adjudicated in secure detention. So you can't try to detain them as part of a diversion order. That would be like somehow a judge getting around the requirements of the juvenile code that are trying to divert this young person out of that process that gets them into secure detention. Okay, so these agreements and orders shall not include a requirement that the child's parent, guardian, or custodian undergo medical, psychological, or psychiatric treatment. And you might say, wait a minute, didn't we just see a code provision saying that we can require that? There's a big unless here. Unless such treatment is recommended by a qualified professional, a medical, psychological, or psychiatric professional. And it's necessary to address the conditions which contributed to the alleged delinquent act, or it somehow allows the child to remain with or be returned to their family, to their parent, guardian, or custodian. So in this particular aspect where the court is wanting to order these kinds of examinations for parents, guardians, or custodians, it has to be recommended by someone who knows what they're doing, and it has to be relevant to the delinquent act or to get the young person back to their parents, to their home. All right, any questions thus far?
We had a question come up. In case, let's see, in this case, can the same or very similar diversion program be approved in both a deferred adjudication and deferred disposition order for the same youth? For example, if a program was not effective at first, but if the youth or those supporting the youth felt it could be beneficial to try again, could they continue with the same diversion program?
So the model code does not prohibit the possibility of going back to the same program or being diverted to the same program. However, those programs have their own eligibility criteria and decision makers. And so I know you have a juvenile healing to wellness court team, and that team may reject a second person that's brought to them for a second time if they've been terminated from the program. So the code doesn't prohibit that possibility. It leaves that possibility open, but individuals in your system may reject eligibility in your system, and that's outside of the code. That the code has nothing to say about that.
Thank you.
Okay, we may have poll questions next, or is there one more slide? Poll questions. All right, let's do one. Okay, evidence-based practices. You know what? I may have forgot to tell you that juvenile case coordinators, according to the commentators on the code, are supposed to consider preferencing evidence-based practices in the service and programs that they recommend, and include in the directory probably too. So what is an evidence-based practice? Let's see if we know. Select one or more of the following. Best practices from other jurisdictions, something with clinical expertise, something based on available clinical evidence from systematic research. We lost a word there. Promising practices from other jurisdictions. Which one or more of these is an evidence-based practice? And we'll do this one, and it looks like maybe there might be another question.
I do see a question about, are folks not looking at the ABA family court model that is also approved by the, I believe it means NCJ, FCJ Association. It has everything these other courts have, including this juvenile court model, and fits Indian country very well.
Okay. Yeah, I guess I would say a model is not a code, right? It's not a set of statutory provisions. And this model juvenile code, no doubt the drafters looked at other model systems in drafting the statutory language for tribal juvenile courts. So other state models are based on state statutory provisions. And we're just trying to get the law right for tribes, or at least get it therapeutic and not punitive, because that isn't working. I mean, it simply hasn't been working. But I do understand the inspiration of the model from other places, and the spirit of it very well likely is in the model code or behind the model code. Okay, let's see what folks said. So most people thought clinical expertise is an evidence-based practice, and you are right. And a lot of people thought that, oh, I had it wrong. Most people thought that it's based on the best available clinical evidence from systematic research. That is also correct. So the two middle ones here, clinical expertise and based on best available clinical evidence from systematic research, those are the right answers. The wrong answers, what is not an evidence-based practice is a best practice or a promising practice. Now, why do tribes always end up having to work with best practices and promising practices? It is because there has not been enough clinical evidence from systematic research done in Indian country. There's not enough research done in Indian country. And so we're hogtied. We can't do best practices because there's not enough research demonstrating best practices. And so we're often left with best practices and promising practices. This is a known problem. We need more research, but we also need to look out for evidence-based practices that might work in Indian country. Those will be usually pretty easily supported by federal funding because they're already demonstrated in other places. But there is some irony in that an evidence-based practice researched on another population is not an evidence-based practice in Indian country. So this is a highly controversial area. It's problematic. The bottom line is we need more money and research in Indian country. Okay, we probably have another poll question.
Yep, we have two more for this section. This one and then one more.
Okay, so evidence-based practices include select one or more of the following: motivational enhancement therapy, cognitive behavioral treatment, medication-assisted treatment, relapse prevention. Select one or more.
All right, and responses are still coming in steadily, so I'll leave it up for another 5 seconds or so.
All right, so most people are picking the bottom three. The correct answer is all of them. Now, these are all evidence-based practices in the nationally, right? So the research has not necessarily been done specifically in Native communities. These are the mainstream evidence-based practices. And a number of tribal healing to wellness courts do one or more of these things. I saw in the early years a lot of cognitive behavioral treatment, some motivational enhancement therapy, relapse prevention for sure, and not until more recently have I seen medication-assisted treatment, because in the early years of drug courts, that was really controversial, even in the mainstream drug courts. But today, these are the evidence-based practices in the mainstream. By the way, this list is not comprehensive. There's more, but these are the ones that I saw most often in Indian country. And Anna, I don't know if you wanted to say anything about this.
I was just going to reiterate that the lack of kind of research and literature, and then also the consideration of practice-based methodologies that are used in tribal communities, and how do we integrate those approaches as we look at kind of revision of our overall code and policy development in the juvenile justice system.
Yes, exactly. We may have one more poll. Okay. The reasons that it could be difficult, or that it is difficult to use evidence-based practices in Indian country include, and you may select one or more of the following. And by this one is really what you're seeing. I want to know what you think. So some of the reasons that you see might be there's little to no systematic research conducted in Indian country. 2, Native communities want to replace evidence-based practices with cultural programming, activities, practices. 3, evidence-based practices need to be carefully designed and implemented with culture in them. 4, drug court focuses really primarily on criminogenic needs, but not on values in the drug court model. So I'm asking you, which of these 4 are a reason that you think it's difficult to use evidence-based practices in Indian country? And you can pick more than one. And criminogenic need is like they're looking at whether a certain young person is likely to commit crime in the future, and how do you intervene to make that less likely. They're really looking at criminal aspects and not more general value systems of that young person and their family. Okay. So most people, 80%, are saying there's little to no research in Indian country, or systematic research. There's research, but it's not systematic. That would be, I agree with that 100%. And then next, people said Native communities want to replace evidence-based practices with culture. I definitely see that as well. And we probably should have, so I guess the criticism would be, does culture heal people? Are we showing that it actually works? I mean, we know that people believe it works and that they design it that way to work, but does it actually work? And that would be the studies aspect. And you can study the cultural interventions to see if they work. You just have to have the money and the people to do it. The next one is 60% need to be carefully designed, and it goes hand in hand with the one above it, with culture. And the last one, wow, more people picked the last one than I thought. Drug courts focus on criminogenic need, not values. They do. And if you cut and paste the state drug court model into your tribal court, you're going to be prioritizing criminogenic needs over values. And so you want to take a hard look at when you develop your handbook, or your gosh, there's another word for it. Well, your policies and procedures guide and your handbook. And if you're just copying the state model, you want to watch out for this one. because you may care also about values and not just about criminogenic needs. Okay, any questions at this point?
I'm reviewing our pod, no questions at this time.
Okay, next slide. All right, so I just wanted to remind us all that there are a whole bunch of Native youth who may still be stuck or proceeding through the juvenile court process, and they have to do an initial hearing, and they have to go to an adjudication trial, and they may be sentenced or have a disposition hearing. So let's come back and just remind ourselves that there's this other group of our young people who are in this system that don't get diverted. So let's go to the next slide and look at initial hearing. So remember, this initial hearing is what they call a probable cause determination. And that means that the judge is trying to figure out if the delinquency petition establishes probable cause to believe that the child has committed a delinquent act. So he's really looking at whether the juvenile presenting officer in writing the petition included enough evidence of, for example, the fact that Adam, Barney, and Charlie committed assault against Harold by recklessly causing him physical injury in our sample case here. In other words, did they commit a delinquent act, and is there enough evidence? Are there witness statements? Is there evidence of the broken arm? Is all of that in the petition? And does the judge think that there's probable cause to believe that these boys have committed a delinquent act? Well, in order to answer that question, if you're the judge, you have to know what probable cause means. And so the judge is going to ask himself or herself, would a prudent and cautious person believe that these facts are probably true? Will a prudent and cautious person have a reasonable amount of suspicion supported by these circumstances to believe that these facts are probably true? And so the judge is sort of just standing in the shoes of a reasonable person and looking at that delinquency petition with its evidence, trying to figure out if there's enough there to let this case go forward to a trial. That's a probable cause determination. And that's what the code requires. Okay, next slide. All right, so if there is probable cause, if the judge looks at that petition with all of its assertions of delinquent act and evidence supporting it, then the judge can set a trial, an adjudication date, and that's another hearing or trial that happens down the road. Now look at all the code provisions that start kicking in under the model code. Code provisions that are talking about admissibility of evidence and privileges against self-incrimination, also burdens of proof and advisement of rights, and whether the court will accept an admission or not. And then of course there's court findings on the adjudication after the whole trial happens. So a lot of fancy court process happens here, unless the young person just admits that they did it at the beginning of this. But remember, the model code has a whole bunch of process of what it takes for the judge to take an admission. It really protects the rights of young people. That judge is going to question that young person. They're going to question their lawyer, the presenting officer, the case coordinator, and they're going to there's a lot of questioning going on before an admission can come in. Okay, so let's go to the next slide. We're on the adjudication. So the purpose of that hearing is for the judge to determine whether the child has committed a delinquent act. And then the judge, after hearing all the evidence, is going to make a formal set of findings and a judgment. Is this young person, have they committed a delinquent act? Are they a juvenile delinquent? Yes or no? It depends on whether or not that got proved in the adjudication or the trial. Okay, next slide. Okay, so who has to prove it? Well, the juvenile presenting officer has to prove it. That is the lawyer who would have been the prosecutor if it were a criminal proceeding. And that juvenile presenting officer bears the burden of proving the allegations in the petition beyond a reasonable doubt. What does that mean? Well, this is the criminal court level standard, the highest standard of proof. It is the hardest standard of proof. So the juvenile presenting officer is making a claim that this young person committed a delinquent act. So when they present their evidence to the fact finder, who in a juvenile court is not a jury, it's a judge. And these are considered bench trials. That means the judge is the jury. So in these cases, the juvenile presenting officer has to eliminate any reasonable possibility that they are incorrect. So their evidence has to make it look like there's no reasonable possibility they're incorrect. It can't look like somebody else might have done it, given the evidence. And if the JPO leaves even the slightest doubt in existence after their case is over and they presented all their evidence, they will lose their case if they leave the slightest doubt. So this standard of proof is really high. It's not a standard of proof that we typically saw in juvenile codes, tribal juvenile codes. The drafters of the model code felt that this was the best rights protection that we could have for youth who have to go to trial in a tribal juvenile court. And so they are insisting that we use beyond a reasonable doubt instead of a preponderance of the evidence standard of proof. That standard of proof would only, the juvenile probation, the attorney for the tribe would only have to prove the case. They'd have to be more convincing than the other lawyer. And that's a much lower standard of proof. Okay, so lots of legalese here. All you got to know, it's way harder to prove that a young person committed a delinquent act in the model code than it used to be under most tribal codes. Okay, any questions?
I do not see any questions. Oh, this is an additional question. Will there be a webinar discussing the relationship between the Office of Juvenile Court and Native American Tribes and truancy? So I think this is in reference to some broader TYRC training. So I can answer that individually. I'll send a message for that.
Okay, great. Oh, and I should just say that there's a whole third part of the model code that governs truancy, and we haven't presented much on that in these webinars because they're so rights focused and therapeutic diversion focused. And of course, I can talk to our organizers here and ask them if that's an aspect that we want to develop for the future. Okay, next slide. Okay, so our lessons learned today, and we'll do some, if we have time, we'll do some more polls here in a minute. Our lessons learned today are 4. First, there are key positions under the model code. The guardian ad litem, the juvenile advocate, who isn't a lawyer, that person is a lawyer for the youth. Juvenile case coordinator, that person is like a probation officer plus. The juvenile presenting officer is who used to be the public defender in a criminal process. They're the tribe's lawyer. Number 2, the juvenile case coordinator under the model code fills the role of what was once called the juvenile probation officer, but with an expanded role, importantly including the creation and maintenance of a directory of services. That's a big important provision in the code. 3, the model code provides for 4 potential doors to diversion from the juvenile court process, which include the diversion agreement, the order deferring adjudication, the order deferring disposition, and the disposition order itself. And 4, remember that if a young person's case is not diverted from the juvenile court process to a program or a service like Tribal Healing to Wellness Court, the case then proceeds in juvenile court through the initial hearing to the adjudication trial and through the disposition hearing. And there are also review hearings after the disposition. And there is a potential that that young person will be placed in secure detention if they stay in the juvenile court. So it's a big deal whether or not someone gets diverted out of the juvenile court. It can make life-changing differences for them. Okay, let's do some polls. Okay, so now I just want to know what you think. Which diversion options would you love to have in your system? Select one or more of the following. Number 1, Elders Panel or Community Accountability Board. 2, Youth or Peer Courts. 3, Victim Offender Mediation or Reconciliation. 4, Structured After-School Programs. 5, Healing to Wellness Court Programs or Drug Courts, aka drug courts. Pick one or more of the following. Okay, so looks like lots of people would like youth or peer court, 64%. About 64% would like victim offender mediation or reconciliation, and 64% would like structured after-school programs. And then not far behind are the others, Elders Panel or Community Accountability Board, and lots of people still want Healing to Wellness Court programs. So all of these are popular. Okay, next polling question. What is the purpose of an initial hearing under the Model Code? Select 1. Is the purpose of the initial hearing to take pleas of guilty or not guilty from youth? Is it to determine whether there is probable cause to believe that the young person has committed a delinquent act? Or number 3, is it to determine whether there is probable cause to detain that young person? Or number 4, is it to determine whether the youth should be removed from the home? Which of these is the purpose of the initial hearing under the Model Code? Choose only one. %62. To determine the purpose of the initial hearing is to determine whether there is probable cause to believe the young person committed the delinquent act. That's the right answer, the second one. Whether there's probable cause to detain, it is true that in most initial hearings in tribal court, they're also determining whether or not they can detain on an emergency basis a young person. But that is actually not the primary purpose under the Model Code for the initial hearing. You might be able to do that, and I need to look it up to see if you can do emergency detention. But you know what? The more I think about it, I bet they don't let you do that under the Model Code easily because they don't like detention. But I will look that up, and maybe I can put some of that answer in the next session. All right, was that the last one? Oh, one more, sorry guys. Is this the last one or is there one more?
There's one more after this.
Okay, we'll do the last two here. So what happens in an adjudication or a trial under the Model Code? Select one or more. So number 1, the judge determines whether the juvenile committed a delinquent act. Number 2, the judge takes evidence and makes findings about whether or not the juvenile committed a delinquent act. 3, the judge gives the juvenile a chance to admit or confess to having committed the delinquent act. 4, the judge advises the juvenile of his or her rights. Select one or more. Okay, so most people pick the first 2. The right answer is all of them are things that happen in an adjudication under a model code. But the primary purpose of the adjudication is that the judge determines whether the juvenile committed the delinquent act. So that one kind of was a trick question. Purpose versus what happens. Okay, let's do the last one. Oh, I have a question in the pod. Anna, do you want to grab that question?
Mm-hmm. This was about detaining youth during the initial encounter with law enforcement. How frequently does law enforcement overestimate the youth's age? And that might be a question that could be asked of our entire audience.
Yeah. Remember that under the model code, it's possible for a juvenile court to exercise jurisdiction as late as about age 25. So all of the rights protections that are in the code are going to apply to youth who are a lot older than you think, which will make it likely that law enforcement will not realize that they need to see people that are older as coming within juvenile court jurisdiction.
I think also looking at the diversion opportunities, specifically the CTAS Purpose Area 8, I believe that age limit, the upper limit was increased to age 21 to accommodate those youth who are, you may still have 19 and 20-year-olds that are in high school, just developmental or educational issues that come up, and they remain in a high school setting and encroaching on even 20 at sometimes.
So that suggests that the model code has a wider window or age range. So it allows, if you adopt its provisions, it gives your court jurisdiction over a broader age range up to 25, but your programs might not be funded up that high. So some programs may only be able to make eligible people up to age 21, even though your court would have jurisdiction to divert them to programs up to age 25. So it sounds like you really have to be careful when you craft your programming to protect your funding and make sure your eligibility requirements are what they have to be.
There was another follow-up to that question was, is there more information on this topic? And I don't know if that was specifically to the law enforcement encounters or in general related to age of majority. And I do think this is a great discussion that we could have, and we have some opportunities where we could do some additional training and discussion on trends in tribal code and looking at the age of majority in different communities.
Yes, and I'm realizing that we should probably do a law enforcement take on the code provisions from their perspective, and compare what they tend to do to what they would now have to do if a tribe adopted the model code. Okay, let's do the last poll here. What should happen to those youth who are not diverted? Select one or more of the following, and I'm just asking what you think here. 1, they should be placed in a secure detention facility. 2, they should be placed on probation. 3, our tribal court should not handle these cases. 4, these cases should go to state court. And I know you probably have more choice selections in your mind than I gave you. So it's looking like the practical reality is that they'll probably end up on probation, from what I'm hearing from you here, under 79%. And some of them will be placed in a secure detention facility. And there are some times when that is the best thing that you can do, because they may be very dangerous, especially if we're starting to take older youth into tribal court jurisdiction, tribal juvenile court jurisdiction. And then a certain percent of you do think that cases should go to state court. And I'm up in Alaska, so there is a strong argument for that, where the state court has all the resources. They have the money, they have the programs, they have residential care, they have, you know, they've got all the stuff, and you can't just leave young people out in the cold. They have to have somewhere to go. These last two answers really are about resources. And we've got to keep talking about that and making sure we pull more in to tribal communities. Okay, any questions, or Anna, did you have any thoughts?
There were no additional questions. My thoughts are just that we have a lot of room and space for additional training with some of the things that came up today. So I'm excited about that and appreciate the questions that were submitted today.
Okay. And I guess I'll turn it over to you, Anna, to close us out.
Thank you, Pat. And again, thank you to all of you who have joined us over the past several sessions. So today is the end of session 4. We will have one more session in March. That will be our final session of this particular series. But as I just shared, plenty of dialogue and discussion that can continue in reference to many of the questions that came up today. So again, thank you for your presence with us today. I appreciate and hope that all of you remain safe and healthy. I'm thankful for your time and for the work that you do in your communities. And I believe that there is an evaluation link that we would like to share. And there is space on there if there's additional training topics that you're interested in, to submit those as part of the evaluation. So we invite you to do that as you close out your time with us today. And Laura, if there's any other comments regarding the evaluation, please feel free to share.
Thanks, Anna. Nope, that's it. And thank you, Ashley, for putting that in the chat for us. So the link to the evaluation is there, and we'd be really grateful if you could fill it out. Thanks, everyone.